So, Michael, welcome on the Insurer TV.
Awesome. It's wonderful to be here, George.
So, you recently highlighted that legal consults for insurers could face losing their attorney-client privilege if they do anything outside mandated legal work.
Yeah, there's a developing, set of case law in the United States where different courts have said that if coverage counsel, whether they be outside counsel or in-house counsel, do things that the court deems to be within the traditional realm of a claims professional, that makes them somehow not a lawyer on the case and it makes them into a claims professional. So any sort of communications that might happen between counsel and the insurance company is not covered by the attorney-client privilege.
And so what do you think the ramifications of this could be for the insurance industry?
It's very difficult because when insurance companies have claims, particularly liability claims, they, oftentimes need to go to counsel to advise them on their coverage obligations, their rights, et cetera. Because in the United States, we are 50 different states, and different states can interpret the identical policy language very differently. We also have different sort of rules and regulations and procedures on how, these sort of coverage disputes are litigated. So carriers go to outside counsel and their in-house folks to sort of get advice on what to do. And, these are not often easy cases, right? If they were easy cases, we have an occurrence policy that for 2003, the accident happened in 2002. That's an easy one. You don't have to go to outside counsel or in-house counsel for that. But these are more difficult questions. And if the insurance industry cannot get candid advice from their counsel as to, how they should proceed in a case, that's very difficult.
And so what kind of things were legal counsels doing that was seen outside their mandate? So you saying giving candid advice was one of these?
Yeah, that's right. Sometimes just giving advice. Some courts have said, well, if the insurance company relies on that advice in making its decision, that may not be privileged. For goodness sakes, if they're not relying on advice, why are they going to counsel to begin with? Right. It's sort of, this isn't Seinfeld and George Costanza where we're going to do the opposite of what counsel says. That's one of the problems. But then it's also things like, drafting reservation of rights letters, drafting declination letters, talking to a witness, perhaps, advising the insurance company. Here are the four things we probably need to know from the insured in order to give you quality coverage advice. These sorts of things, different courts, not all courts, not even a majority of courts, but some courts are starting to say those are not lawyer things, those are adjuster things. And therefore, if you do any of those, there's no privilege on all your communications with respect to that activity.
So with this precedent, you can no longer ask for advice from your legal counsel and remain attorney-client privileged.
That's the problem is that, because I had a class with my law student. I teach an insurance law class here at St. Louis University, and we were going over this doctrine. And one of the students said, my goodness, the legal advice is tied together with these different tasks that counsel are doing. If an adjuster says, here's my draft reservation of rights letter and sends it to counsel, well, yeah, I could provide legal advice. Is this sufficient or not? But how different is that really than like editing the letter, and how different is editing a letter from drafting a letter, right? Because we're doing these things because built into these tasks, we're giving advice to the insurance company that this is what complies with the law, that this is what you need to do. And if we can't do these sorts of things, then you have claims professional sending stuff out, perhaps doesn't comply with the law because that's what this doctrine is potentially forcing us to do.
And insurance carriers are really struggling with social inflation at the moment. Do you think this is adding to their worries around social inflation?
It certainly doesn't help. It certainly doesn't help because they're not being able to get, candid advice on these things, and to take it sort of to the next level, George, there's even a federal district court case out in Washington that says a claims professional has an obligation to conduct legal research to make sure that their coverage decisions comply with the law, even if that claims professional is not legally trained, doesn't have a law degree. So it's like, well, let me get this straight. Someone who hasn't gone to law school has to pretend to be a lawyer in making their decisions. And if they consult a lawyer, guess what? Now there's no privilege of these communications. So anything that the lawyer now sends to the insurance company, potentially in litigation, we have to turn over to the other side and let the other side see all of our pros and cons and the risk and all the potential weaknesses that we identified in arcane advice. And now my adjuster has to sit at a deposition and be cross-examined over what they thought was confidential. Something that I wrote for them now becomes Exhibit 47 in their deposition. So does that increase the value of claims? I certainly think it does, or at least certainly the settlement value of them.
Yeah, it definitely seems like it can make the law courts a more hostile place for insurers.
Exactly.
And what states are we seeing this occur?
Well, the big one, that many people felt like this started was the state of Washington. It was a Supreme Court decision from about 2013 that started that. Everyone thinks that's where it came from. It actually didn't. There were a couple federal court judges, one in New York and one in Indiana, that sort of started the ball rolling on this. Washington took it as it does and, basically said, hold my beer, and blew it up into a very big decision. And so the industry at first, my perception of it was sort of like, okay, this isn't great, but it's Washington. They're just crazy out there. But now you're starting to see states like Mississippi do it. Missouri has looked at it. I don't know if they'll ultimately adopt it or not. Oklahoma has looked at it. And, obviously the federal courts in New York have really taken and run with it with some recent decisions. So it's not a majority. It's not even a strong minority, but it's certainly a developing trend that everyone has to look at.
And Michael, why do you think this precedent came about in the first place?
My thought on that, George, is that what the courts are really concerned about here is that, there's this notion that the insurance company is hiding the decision maker from the other side. I think a lot of times, insurance companies may have outside or inside counsel do things like prepare letters, and then they send them to the claims professional. They just sign his or her name to them and they go out the door and don't have a full understanding as to, what's in that letter or what the decision is. And then when we get into litigation, that claims professional is deposed and they can't explain the letter that they sent, the decision that they made or what they said. And then the other side wants to depose the person who actually wrote the letter, and the insurance company says, well, wait, hold up. That person's privileged. You can't talk to them. And it's like, well, wait, does that mean I can't, that no one from the insurance company can explain the position? And I think you see that in the Mississippi case. You see that in some others. And I really think that's really one of the things behind this is the courts feel that insurance companies are hiding the decision maker, that they're inoculating themselves from having to explain their decision. And so I think one of the things that carriers can do to sort of, cut that off at the pass, if you will, is to make sure that the person signing that letter can explain 100% what's in it. And if they can't, we need to find someone who can, someone else in the company, or maybe it is outside counsel and we know that the privilege may be waived. But at the end of the day, whoever signs that letter has to be able to speak to it. And if they can't, we just sort of open the door to this sort of argument.
And are there any workarounds that insurance carriers can use to minimize their risk?
Well, I don't know. I mean, in the states where this is not the law yet, you can first argue, of course, that, this shouldn't be the law, that this is not a good application of the attorney-client privilege. But in 40 plus states, we don't know if that's going to work or not, right? Because we don't have strong decisions on that. So I think the best thing that the industry can do is just to recognize that this is there and deal with it, right? And sort of have conversations with counsel. Hey, do you think your state or your jurisdiction is likely going to follow one of these rules? And if so, that may, affect how you handle the claim, right? Do we want outside counsel or in-house counsel writing coverage letters? Do we want them advising on certain things? If I know my privilege is going to go away, if I talk to this person about this stuff, maybe I don't do it. On the flip side, maybe I do it. Right? Maybe I need, this is a highly technical letter. I need to have counsel write it, but I'm going to go into it knowing full well that there may not be privilege here. And so that may affect, maybe I don't ask for the 47-page coverage opinion that's going to hit me over the head at a 2-day deposition. Maybe I just have them write this letter. So to me, it's just sort of recognizing that this is out there and dealing with it. Because I think one of the problems I see that the insurance industry has is a lot of times we do things because we've always done them that way. We always have outside counsel sign letters. That's just the way we do it. To me, you have to step back and say, should we continue doing it that way? Because there could be problems if we do.
Well, Michael, that was super interesting. And thanks so much for coming on the Insurer TV.
Absolutely, George. I enjoyed talking with you about this.